Okay, there will be time for general discussion afterwards, so let's thank Liliana again. And now we've got our second presentation, who will be given by Chloe Kennedy. She's just completed her PhD and will have her graduation very soon. She's a researcher at the School of Law of the University of Edinburgh, and she's going to talk about the role of documents in historical and interdisciplinary legal research. So, Chloe, all yours.
Thank you, and yeah, thanks for the invitation to be here. I think I'm going to get a lot from this session. I really enjoyed the last speaker, Liliana. So yeah, I really enjoyed that. I'm afraid mine's probably going to sound a little dry compared to Liliana's presentation, but hopefully it will be beneficial to some of you nonetheless. So yeah, I'm the only participant, I think, from the law school. Is there anyone here who's actually doing anything to do with law? Okay, and I think you do history. I've met you before, yeah. Okay, that's good. So this might be obvious to you then, but to the rest of you, perhaps what I thought I'd start by doing is just by giving you an outline of the kinds of documents that people tend to rely upon when they're undertaking legal research, right? So the most obvious ones are judicial decisions. So when a court makes a decision, it's reported somewhere, this is the first place that a lot of lawyers will tend to go. You also have statutory provisions, again, pieces of legislation that are enacted by the legislature, academic commentaries, as you'd expect, also some theoretical works too. All of these are used to different extents and in different ways by people undertaking different kinds of legal research. So one of the most common types of research that someone might do as a legal researcher is what's called doctrinal research. So this, as you might expect, involves trying to understand or to critique an area of law, so a particular legal doctrine, and that might be from the point of view of trying to clarify what the law is in that area. It might be to criticize certain decisions on the basis of their coherence, their kind of fit with other decisions that are out there and other pieces of other sources of law. It might also be to appraise the law on more normative grounds, and these normative grounds can be drawn from a variety of sources, but generally speaking, they are external, I suppose, to the law in the sense that there's some kind of way in which the law might be assessed against a norm which has been drawn by the legal researcher from whichever field, I suppose, they're interested in, or perhaps even developed by that researcher themselves. That's doctrinal legal analysis, but there's many other types of legal analysis too. The other sort of major kind of realm, I suppose, is theoretical analysis. So here, as you'd expect, you have people who are working on trying to develop and critique theories of law. So not looking at actual documents which contain legal decisions or possibly using those documents, but with a view to trying to create a theory of how perhaps individual areas of the law work, criminal law, for example, or private law, or perhaps law as an entity, a distinct entity in itself, or even legal reasoning. So you have people who are creating and critiquing theoretical models of law, and often they will use the same kinds of documents as doctrinal lawyers, but in a very different way. So that's just a brief overview of the kinds of sources that people who undertake legal research might go to, the kinds of documents they might use in undertaking their research. So what I want to do for the rest of today is to talk a little bit about my own research, not in a huge amount of depth in terms of the substance, more to do with the kinds of methodologies I used while undertaking the project. So this was my doctoral research, which, as Miguel said, I completed relatively recently. And the thesis itself looked at the way that Calvinist Presbyterianism and Scottish Enlightenment philosophy, which I argued could be interpreted as a kind of tradition of Scottish moral thought. The way that these schools of thought, if I can just label them as that for the purposes of today, had an influence over the way that the criminal law developed in Scotland. So the project was, as you can tell, historical because I was concerned with the development of the law. It was interdisciplinary because I was looking at religious and philosophical ideas and the way that they interacted and influenced the law itself. And the legal element is fairly obvious. I was looking at criminal law in doing my research. Just to give you a small bit of background information about the timescales involved, this will sound hideously overambitious to most people who are historians in here, but I was looking at kind of the mid-16th century right through until the present day. Hopefully, when I explain to you how I did this, that will sound less just implausible, but yeah. A bit about the materials I used in doing this. So the thing about doing, I suppose, I can't speak for history in general, but legal historical work, at least in the field of criminal law and at least in Scotland, is that when you start looking quite far back, in some senses, your sources are kind of dictated to you. There's a limited amount of material that's actually available and accessible. So for me, the starting point in the 16th century was to look at what are called practics. Now, these are basically just compilations of legal practice put together by individuals, which are supposed to reflect the way that law actually operated at that time. And there's one kind of key text for the 16th century, which I used for that time period. And then from that point onwards, up until the advent of regular kind of reported legal reports, regular legal case reporting, I used a number of different important treaties, again written by individuals, but supposed to reflect the way that law was actually, how the way the law developed and how it was used at that time. So the picture on here is of a really important book called Commentaries on the Law of Scotland Respecting Crimes, written by Baron Hume, nephew of David Hume, after whom this building is named, of course. And this book is really important, published in 1797, because it's attained the status of what's known as an institutional writing. So within Scots law, there are these various texts which are quite unique, because although they're written hundreds of years ago, they're still relied upon in court and in academic writing too. They still exercise a lot of influence. So this text was a kind of pivotal one for me, because it was helpful in describing the way the law had operated until that point, but it also gives some indication of how the law has developed from that point onwards. It's this very, very important text for that reason. So that was, as I say, published in 1797. Case reporting the regular case reports came in around about the 19th century. So for the time in between that period, those two dates, my sources that I relied upon were archival materials. So I went into the archives on Princes Street, and never having done this before, never even having studied history, again, many of you probably be appalled to hear this, I went to the archives and began sort of digging around, trying to find things that might be helpful to my argument. Now, what was really interesting about this experience was that the materials I wanted to look at were not indexed at all, nor were all of them available to me. Some of them were just in too poor a condition to actually be accessible. And so what I did was, I only retrospectively learned that this was what I was doing, but purposive sampling. So going in, looking through, essentially flicking through handwritten 19th century case reports. This is an earlier text, but it gives you an idea of the kind of handwriting I was also encountering. But yeah, flicking through, just trying to find things that might be relevant once I found them and use them for my own purposes, hence purposive sampling. And then from that point onwards, from the 19th century onwards, I just relied upon sort of published case reports, which are of course much more accessible and easier to search through. So enough about the legal materials for now, or just in the time I have, I want to give you an overview of the way, it's this very whistle-stop, I'm afraid, but the ways that I approach dealing with the religious and philosophical materials that I dealt with, the ones that I looked at. So again, I mean, it's really difficult, as all of you will appreciate, to know how to start these kinds of projects, especially when you're trying to deal with something that's fairly nebulous. This is sort of cart before the horse scenario, where you're trying to figure out exactly where you start looking and what you're looking for, and it all seems like that picture that Liliana put up was perfect, just a mess. Nonetheless, what I did was just simply went to some secondary materials to start with. I read about the history of philosophical thought, the religious history of Scotland, the social history of Scotland, and from that point I chose the primary texts that seemed like they were going to be the most important for me, and then I went to those and read them in their original form. I want to just talk a little bit about how I try to make these connections that I've been referring to, this influence I've been talking about, because the documents I looked at, that's all well and good, possibly relatively interesting, but the biggest challenges for me were how to actually go about constructing an argument from these, especially, like I mentioned, when you're trying to deal with something that's fairly nebulous. And the first problem or challenge I dealt with was really, what is it I'm trying to prove, and what do I mean by proof? How exactly, what kinds of arguments and what kinds of evidentiary standards were appropriate for my task? And one of the things I encountered was that a number of historians would take the view that to make this kind of argument, you really have to be able to point to specific examples of interaction, right? So this jurist studied under another jurist, or attended certain sermons, or pointing to really kind of tangible links between people and between texts and people. And that's great when you can find them. That was some of the arguments I made were on that basis, and they're obviously extremely strong connections that you can draw. But for the most part, to be perfectly honest, what I was dealing with was much more correlation than causation. I was looking at the kinds of ideas that were influential at the time and trying to find traces of these ideas within the legal writings themselves, looking at ways I could plausibly suggest that they have some kind of form of influence. So, like I say, what I was concerned with is much more correlation than causation. There's also this other issue, which Quentin Skinner, all of you probably will have heard of, an intellectual historian who talks about the mythology of prolepsis, a way of describing the phenomenon of, or rather the potential for reading an idea or a text with a very contemporary view of its importance. So thinking about how its significance has evolved, rather than thinking about its significance in its contemporary context. That's a problem, because obviously if you're looking back with retrospective, with hindsight, you might place too much importance on a certain idea or text, or likewise you might see other instances of that idea and regard them as somehow the predecessors or the successors of that idea, whereas actually perhaps the way they're understood in their relevant context is really quite different. So that was another thing that was kind of at the top of my mind as I was doing this research. And the sort of related question is how can you maybe make arguments about history that have some bearing on the present day? Like I say, my project had some ambitions to say something about contemporary law, the way that Scots criminal law operates today. So I had to think about, well, how can you make these kinds of claims? So my solutions, the scare quotes are there because obviously this is just something I did. It's not the way it's necessarily should be done. There's a few different ways I tried to tackle these difficulties and these challenges. And the first was to make reference to and to keep in mind the particular social context. So when I was looking at writings, I was always trying to keep one eye on, say, the political affiliation of the writer, the sorts of events that were going on at the time. The Covenanting prosecutions is a really good example of that. Trying to think about these things. I obviously couldn't take into account every kind of socio-political factor that was going on at the time, so I had to be fairly focused in my efforts, but keeping one eye on context was one of the ways I tried to avoid the mythology of prolepsis. The second way I tried to combat these try to meet these challenges was to try to make sure that I always pointed out that when I was saying, for example, something that happened in the 18th century, a particular way of thinking about law that cropped up is perhaps reflected in later works, later legal works. I wasn't trying to suggest that the same ideas were informing what was going on. There was no suggestion that there was a sort of teleological progression or that there was an essentialist strand to my argument. I tried much more to say, well, this is just something I can point to suggest that there's something like a tradition of thought. And lastly, what I was very conscious to do at various points in the thesis was to explain that, or to point out that my explanation I was putting forward was not by any means, even in my own eyes, the explanation of how Scots law came to be how it is, Scots criminal law how it came to be how it is. It was just an explanation, one which no one else had made to that point. So I think just being kind of relatively cautious in your ambitions is something I tried to do throughout. So just to draw some general reflections about my own research, as I've been alluding to already, I think one of the ways that making this kind of interdisciplinary historical argument, the kinds of arguments I've been describing, the ways that it's possible to constrain the difficulties that you might encounter while doing this kind of research is by being aware of different perspectives on sort of bring it back to documents, I've kind of strayed away, the value of the documents you're using and the arguments you're making. Be aware of different schools of thought within your field. How is it that, say, historians might conceive of doing history? And if what you do differs, just be conscious of the fact that there's a difference and be able to explain why it is that you've taken a different approach. And second of all, yeah, kind of linked as well, I suppose, demonstrating awareness of the limitations of your sources and your arguments. So it may be that somebody else completely disagrees with what you're saying, but as long as you can defend your ideas on their own terms and explain why it is you think there's some plausible backing to the terms you've set yourself, then that's definitely something I would advise doing. Okay, thanks.
Excellent timekeeping for Chloe as well. So yeah, we've got time for a few questions or comments. Toko?
Thank you, Chloe. That was really interesting. I want to just go back to this issue that you were on to at the beginning. It does seem like a huge project, really ambitious. I mean, it's great to do. I'm really kind of impressed. But how did you manage it?
That's a really good question. Honestly, when I started out, I didn't really know exactly how I was going to manage it at all, and certainly I had worried supervisors too. The way I dealt with it really was to focus on the fact that within the time period I was looking at and the context I was looking at, Scotland, criminal law, there were natural points of focus. So those might be big legal texts that were written, or it might be a big event that happened within Scottish history, or a big text that's written on, say, moral philosophy. And I kind of centred my analysis around those. I didn't try to fill in all the gaps at all. It's much more of a kind of join the dots type of exercise. And I also structured the thesis by theme. So the chapters were structured around areas of criminal law scholarship. So first of all, there was a couple of chapters on the scope and the principles of the law, what was the kind of justifications put forward for why certain things were criminalised. Then there was a separate section on criminal responsibility, ideas of responsibility, attribution, and also the ways of denying responsibility. And last of all, I looked at, what was the third thing? Oh my God. Responsibility, scope, and it was sort of generally to do with the way that the law was applied. So sort of ways that it was put into practice, ways that prosecutions occurred. So yeah, organising it thematically and realising that the time period I was looking at was going to require certain focal points, which I chose for myself.
So thank you very much for this presentation, very fascinating project. I was intrigued by your distinction you made at some point between causation and correlation, and I was wondering whether you could elaborate on that, or where is there a place that I could look where this has been developed for the study of documents? I mean, it reminds me of my former life in statistics, where this is a very important distinction, but it's really fascinating because I'm also working with documents and I can immediately make sense of this distinction in my own terms and totally makes sense. So I would be interested to hear.
Sure, I'm glad it makes sense. I mean, it is just taken from basically statistics. I just used it as a kind of organising distinction for my discussion. There might be work out there that specifically talks about these issues in respect of, documentary analysis. I think it was just something that I was aware of in the back of my mind from having spoken to people. So people might, primarily historians, one person who was on my first year panel was kind of quite keen that I should be able to point to what I then conceptualize as causal links. So who was this person studying under? Who was it that they talked to? Obviously things that are massively important, and if I could have found more of them would have been great for my thesis. But inevitably, if you're talking about something that's much more intangible, then what I describe as correlation is really just, I suppose it might just be called mirroring of certain themes and ideas in other pieces of work and other texts. So, I mean, I'm not sure of any sort of writing I could point you towards that might help you in that regard, but that's kind of what I was trying to get at in using those terms.
You should write something about this.
All right. There's probably lots written on it, I'm just not aware of it.
Also, if someone knows about a suitable reference, please to get together in the break and talk. Yes, please.
Thank you very much for your presentation. Your interest is more of an historical, like you rightly mentioned. Now, would there be a difference compared to some of us that are not in the law field, but are also interested in the issue of contemporary documents? Would people see it differently? Say, for example, the documents that are already in the public domain, as opposed to some of the historical documents which you use that are not in the public domain. So how do you, or what advice, or what would you say as regards to some of what are in contemporary, how or what should we be looking at in the documents in which we want to use to substantiate our either correlation or causation?
I suppose it would depend a lot on what you are specifically trying to show, and which areas of, it is law you're talking about? It's a legal project? Oh. To be honest, I think I'm not really that best placed to answer that question, I'm afraid. I suppose, I mean, yeah, I think probably it would be really important to know exactly which kinds of connections you're trying to draw, because I think, particularly in the contemporary context, given, like you say, a lot more material is out there and in the public domain and is accessible, it might be, I'm just speculating here, but it might be more difficult to actually justify making these kinds of connections I've tried to make. I really don't know for sure, but it seems to me that if there is more stuff out there and it's all accessible, and people maybe are more explicit about what they're doing and more possibly aware of the context in which they're writing, you might find those sorts of correlative claims a bit harder to justify. But I really need to know more about what you're trying to, do, I think.
Okay, I'm afraid we have to shift to the next presentation. Write down the question and there will be time after the three presentations. So, well, thanks to Chloe again. And, well,